Okay, we're going to get started. I was waiting for a few more people to enter the room, and pardon me for shifting around and getting all settled in. So my name is Martha Hartney. I'm the CEO of the Children's Emergency Response Plan and also the Chief Principal Attorney at Hartney Law in Boulder, Colorado. And my team and I have figured out a way to bring one of the essential elements of state planning to all families in the United States. And this is called Children's Emergency Response Plan. This is what I'm here to introduce you to as a parent, and also to familiarize you with the legal principles that you need to know as a parent. And also what issues to look out for, what powers and responsibilities and rights you have. So by the time you leave here in about 45 minutes, you'll have a much greater sense of what your legal landscape looks like and how you can maneuver on that as an American parent. So to just get started, the first thing I want you to know is the stuff that I share here on this webinar is stuff that you are not taught in high school or college or in parenting classes that you went to before your child was born or even after. Certainly not taught in breastfeeding classes. And I know because I was a mom. I went to high school and college, and the stuff that I learned in law school and as a practicing attorney is critically important to families, and it's not taught anywhere. So I made it my mission to go find out what I needed to know as a mom and to bring it out to you as parents so that you don't have to feel like you got to go to law school to figure this out. I'm here to share what I know with you so that you don't have to sift through the internet to find the right information that applies to you. I'm going to give you at least one aspect of your legal life here pretty clearly so that you can make good choices from here. So I'm going to get myself a little bit more comfy. I'm in my office in Boulder. I also live here. If you're a family in Colorado, I do invite you to reach out to my law firm. If you are interested in completing your own estate plan here. And another piece is if you do chat me here, I will take chats at the end. So I'm going to turn chat off just so it doesn't distract me, but at the end I'll check to see what kind of questions you might have. And I do also welcome emails. You're welcome to email me at hello@gochirp.com. That's to our whole general inbox, and your emails will be distributed from there. So I do welcome emails as well. Okay, so I'm going to actually turn this over to my, I'm going to share my slide deck with you just so you have a sense of what we're talking about, but I'll be flipping back between my slides and me. And what we're tackling today is what you need to know to protect your children in the event of an emergency. And we'll talk about the things that happen when something happens to you, what legal issues you need to be familiar with, the flow of custody in an emergency, what your options are in making choices for your children, how the Children's Emergency Response Plan that we've developed works to support you and your family in this situation, how the alerts help you keep your children safe, and we'll also cover what a children's emergency plan can't do. There are some limitations to children's emergency response planning, and then we'll talk about your next steps. A lot of families seek out my guidance to find out what happens to their children when something happens to them. And I'm aware of my own reaction when I was a young mom, thinking about what happened to my kids if something happened to me. It's intensely uncomfortable to imagine the world with your children in it and you not here in it to guide them. Your love for them is immense. And to think about you not being able to be here with them throughout their growing up years, sometimes too hard to bear. And I invite you into the discomfort because it's so important that you allow yourself to feel uncomfortable in order to make shifts in how things go, so that if something did happen, it actually would happen in a way that you could live with. Of course, if you've died, you may not care, but at least as you're going through this life, you will know that your children would be okay. A lot of parents know that there's something they're supposed to do, and they shorthand it as, I think I'm supposed to name guardians for my kids. And they sort of leave it at that. But that actually doesn't go far enough. And so the only search term I know of is like, how do I name guardians for my kids? That's about it. There's not really any other keyword search that you could get online that could give you the answer that you need. So I know that parents know they need to do something, but they're not quite sure what it is. So I'm here to tell you what that is. The first thing you've got to understand are the 3 forms of custody. Let's lay that groundwork. What's custody anyways? When you're a parent, you don't really own your child as property. So there's not like a title to your child, but you have rights and responsibilities to your child. And that takes the form of custody. So there's 3 forms of custody. There's actual custody, physical custody, and legal custody. Actual custody is the person who is holding your child's hand while crossing the street. That is actually somebody who's in contact or the immediate surroundings of your child, who's immediately responsible for your child. There's no legal implication to this. It could be like the teacher's assistant who's walking your child across the street when they're going down the street to check out a store, which I've done, actually. It could be the daycare worker that is just playing with your child. So it has no legal effect. So let's move along, because the next one does have a little bit more intensity. It's the physical custody of your child. The physical custody of your child is a person that you give authority over your child when you leave them behind. So this is a little crass to say it, but when you leave your children, or when you go to like a concert or dinner and you leave your coat at the coat check, you're leaving your coat with someone. You still own it, but you've put them in charge of your coat. The same idea applies to our children when we leave them at school or daycare, that we're leaving our child in the physical care of someone else. They are legally responsible for your child. So this is like your school's teacher, the daycare provider, your au pair. They're responsible for your child's care. But that's not the same thing as legal custody. Legal custody goes one step farther. Legal custody is what the parent takes with them when they leave their child with someone else. It never leaves you. It is your right and responsibility to care for your child no matter what. Legal custody is actually the most important piece, because that's the piece that we have to see to when we're thinking about legal planning for your children. And people often mix up physical custody with legal custody. So I want you to be very clear that those two are separate. Physical custody is not legal decision making. It is just the responsibility to care for the child day to day. The person with legal custody, or the entity with legal custody, is the decision maker. Okay, got it? So moving on. So these are the legal principles that you need. Oh, trying to share my screen now. Okay, sorry for the delay there. The legal principles that you must know are 3. There's, two of them: the Parens Patriae Doctrine and your constitutional rights. And it's the interplay of these 2 principles that tell us how you can plan as a parent for your children in an emergency. So what is the Parens Patriae Doctrine? This is the doctrine that blew my mind when I went to law school as a parent, and I was analyzing the legal principles that I had been learning from the standpoint of a mother, a parent. Parens Patriae means parent of the nation. It actually means father of the country, but in order to be more politically correct, we'll say parent of the nation. It is the doctrinal power that exists in the state to take over the legal care of your child if you can't do it. So this is how people end up as wards of the state. Ward of the state. That means that the state is responsible for a person who is unable to care for themselves. So children are automatically wards of the state when a parent is unable to care for their child, or actually both parents are unable to care for their children. When we don't have a legal caretaker or a legal custodian, then the state is the default legal custodian for our children under the parents' patriae power. This is really tricky because many people think that after them, that their family is in line for legal authority over their children, that somehow grandparents or siblings, next of kin, have legal authority over our children. That is not true. It's the state that has legal authority over our children. It's automatic and you don't need to do anything to make that happen. In fact, it's only you who can do something to alter that. Only parents are able to change the line of authority from parent to state to parent to someone else. So that's what we're trying to help you understand, that only you can do and you need to do. So the way this plays out is, mom and dad go on a date, they don't make it home. First responders are on the scene of an accident, whether it's probably police, first fire, rescue, paramedics, EMTs are all on the scene of an accident with parents. And if you have little kids, you may have the paraphernalia of child rearing in the backseat of your car. Car seats, diaper bag, toys, Cheerios strewn all over the place. Or anything like me, that's what was going on in your backseat. Those items put first responders on notice that you have children. The next thing they are required to do is find your children. And that's because it's their responsibility, automatically transferred already to police and fire, rescue, even coroners who may be on notice that you have children, have to locate your children because it's their responsibility to secure the safety and welfare of your children. So generally, the police or sheriff will send a squad car out to your last registered address, try to locate your children, might knock on doors. It might take them a while to find your kids. I just had a conversation with the local law enforcement agency, the head of a local law enforcement agency, who was saying sometimes it can take hours to locate your children because they're, not readily found. In which case your caregiver may be calling police or hospitals or even 911 trying to locate you if you don't return home. So one thing that SHRP does is makes their job easy to find your children. We want to direct them in how to manage finding your child at all times. So practically speaking, squad car goes out, finds your children, and the first question a police officer has to ask the person who is in charge of your child, hey, are you next of kin? Or do you have some other legal authority to hang on to these children? Because if you don't, I've got to go find somebody who does, or I have to take the children with me. Police and sheriff don't have any choice here because it's their job to secure the safety of your child. If your children are in the care of a family member, police and first responders are allowed to leave your children in the physical custody of a family member. So they won't yank your child away from a family member, which is good. But that does not settle the matter. We're not done here. Because with a failure to place legal custody in the care of a family member or a person of your choosing, the state is going to be the decision maker automatically for the immediate care of your children and also the long-term care of your children. So one thing that you can do is set up a list of 3 or 4 people who have the legal authority over your children in a very small radius of operations around your home town. So we suggest 3 or 4 people. Think of people who you know, that you trust, that your child knows and trusts, to take legal custody of your child, that you're going to empower in writing to take legal custody of your child in an emergency. And we want 3 or 4 people because the first person on the list might be in a meeting. Second person on the list might be out of town. We want to be able to have immediate first responders who can be lined up to respond to your children. And we want to instruct police and sheriff who to call in an emergency. So we've got to let them know also how to get in touch with those people, what are their phone numbers. So a children's emergency response plan is already set up to do all of that for you. If we can notify first responders of who those 3 or 4 people are, they can make the call to those people and get your children together with those legal caregivers, and then they don't have to act. They don't have to intervene. They will, I have been assured that police and sheriff will run an FBI report on the person that they're talking to, just to make sure that they're safe and don't have any outstanding bad things going on. So do know that that will be the case for your child's immediate caregivers. At that point, the first responders step back, and then it's now left up to the courts to figure out who your child's long-term caregiver will be if you're not coming back, and under what powers and conditions and authority they will be able to act. So Children's Emergency Response Plan, we bifurcate into short-term issues and long-term issues. The short-term issues are solved with the Children's Emergency Response Plan that appoints 3 or 4 people in your local base of operation to take care of your children. And then we also use the Children's Emergency Response Plan to provide long-term guardians for your children, so a court doesn't have to make the decision for you. Going back to my slide deck. Okay. Under what power are you able to do this? So we've talked about the Parens Patriae doctrine, Parens Patriae power of the state. Your rights, as we are told by numerous Supreme Court decisions, this is federal law, that you have the constitutional right to the care, custody, and control of your child. It is your responsibility, and only your responsibility, to provide for the short and long-term care of your children. Only you can do this. No one else in your family has the right to determine your children's future but you. So the Parens Patriae power is one doctrinal power, but superior to that are your constitutional rights. So we want you to wield that power carefully, because if you don't, then this is how custody flows. So get familiar with this. We want you to know clearly what happens to your children's custody if something happens to you. So if you're a 2-parent household, or if you're co-parenting, and both parents have co-equal parenting rights over the child, if something happens to mom, then dad is going to just be the 100% total custodial parent. If something happens to dad, mom is going to be the 100% total custodial parent. That's if you're sharing custody, or you're still married, or you're still partnering with your child as a parent. It's a different inquiry when there's only one parent. If there's only one parent, then the very next entity in line with custody over your children is the state. So if you see this diagram, you'll see that custody automatically flows to the state unless you wield your constitutional right to appoint temporary parental delegates for your children so that the state doesn't have to act. So what we're wanting to do is give the state a reason to not intervene in the care and legal custody of your child because you've already taken care of it. Okay, so what options do you have in taking care of your children? You could do nothing and take your chances. You can rely on the beneficence of the government to make your decisions for you. You can rely on courts to decide who will be your children's short and long-term caregiver. If you do that, what you do need to know is there can be fighting over a children's care and custody. One decision that we want you to make, one decision that we want you to make in the Children's Emergency Response Plan is deciding who will children's long-term caregiver will be? Who will have legal custody of your child while they're growing up? And many families that I've met stop here. They just get stumped. They can't make a decision because maybe there's nobody suitable, or maybe there's a disagreement among the two parents. I don't like your family. I don't like this about my family. I don't like my family. I don't like this about your family. We can't find anybody. We don't have anybody in our families who are appropriate. So one thing we'd like to describe to you is what happens if, what happens if you don't do it. If you don't just make this decision for your children, then a court's going to make it for you. A judge in your local district will request family members offer petitions for guardianship of a minor child. And they can only pick from among the people who ask for the job. They say, I want the job. They file a petition. It actually says petition for guardianship of a minor child on it. And it's supported by financials, a home study, testimony and hearings, and reasons why a court should pick that person. So what we hope for is that a family will work together, kind of elevate one person as the person who's going to request the job. We'll send that person in to petition for the guardianship and hopefully get it. But there's no guarantee of that. If you haven't decided, anybody in your family can petition for that. And I have seen plenty of families who couldn't agree on who a child's guardian should be, so they're going to let the court figure it out. And anybody who wants the job is going to submit their petition, and the court is going to lay them all out and pick from among them. So for my circumstance, when I was a new mom and I was married and I had 2 little kids, I was concerned about this. I have 9 brothers and sisters, and my ex-husband had 2. And we had some pretty serious disagreements about who our children's guardian should be. We landed on it, but I did have concerns that there might be multiple parties petitioning for guardianship of my children who actually didn't have my children's best interest at heart. There's some alcoholism on both of our sides of the family. There's some financial need on both of our sides of our families. And I was concerned that people would be petitioning for my children for the wrong reasons, and that a court wouldn't be able to distinguish the better choices from the less better choices. So it was up to us, up to my ex-husband and I, to make that decision. As hard as it was, we picked our guardian and we put it in writing so that a court wouldn't have to second guess our decision making. They would just be able to take us at our word, and as long as that person is a healthy person, they're going to appoint that person as the guardian. It's up to you to make this decision. Don't shy away from it. I'm going to be a little pushy here. It is only you who can do this. And if you leave it to a court, you're defaulting to the government to make a decision for your family that is not the court's business. And as well-trained and well-meaning as judges are, they can only do their best. So don't force a governmental official to make a decision for your family when you should be doing it yourself. Come to the hard choice and make it happen. And one thing about children's emergency response planning that you should know is you can change your mind. We make it easy, we make it quick for you to make the nomination and for you to change your nomination so that you're not locked in, and you can feel that you can make a different choice in your child's future when facts and circumstances warrant it. My observation has been that many families will change their guardianship nomination at least twice while their children are growing up. And the second time will often come when the child reaches high school. You will want to confer with your child on that when they are 12 or 13 years old, and to actually involve them in the conversation. Got it? Okay. So your options are that you can do nothing and let the court figure it out for you. You could try to do a children's emergency response type plan on your own. And you won't know if you did it right. So I can't help you on that one. You could try to do a DIY plan on your own, or you could just plunk down what is really a reasonable price to get this done online from the comfort of your home, quickly, easily, thoroughly, so you can let it go. So the Children's Emergency Response Plan is designed to get you through a process of decision-making to the end of it, to a system of documentation, then signature, witness, and notarization, all from the comfort of your computer. I literally could do it right here, right now from my desk without having to leave my office. And it's relatively inexpensive. So we've built it so there's no longer any excuse. You can get it done, you can let it go, and you can redo it as often as you need. So when I talk about this in public, it's easier to sort of discuss the barriers to getting these things done. And these are the 4 most common questions or objections that I get. People say, I already have a will, it's already done. I don't really need a separate plan for my children, do I? I'm not worried about it because my mom takes care of my kids. And my favorite is, it's not gonna happen to me, so I'm not gonna deal with it. So let's take each of these in turn. A lot of people already do have wills, and they think that they are covered. Sometimes they've even spent a lot of money on an estate plan, several $1,000s, maybe $3,000, $4,000, $7,000, $8,000 on an estate plan, and they think that their estate planning for the children is complete. I will say that it's very likely that if you have worked with a lawyer, that the financial aspects of your estate planning are probably sufficiently planned for, but not your children's planning. Putting a guardianship nomination inside of a will is insufficient. And the reason is, this has been the most common practice among estate planning attorneys for many years, is just sticking a guardianship nomination clause inside of a will. It's not good enough. And the reason is that a will is a dead document until you die, and then it springs to life. Sorry, I'm just stopping my screen sharing so you can see me. So a will is insufficient. A will is a dead document until you die, and then it springs to life when you're dead. What if you're not dead? What if you're in a coma, incapacitated, delayed, detained? There are many, many things short of dying that could prevent you from taking care of your children and necessitate that someone else take care of them. So we don't want to embed it in a will. We want it freestanding. Another reason why we don't like this way of nominating a guardian for your children is it fails to take care of the short-term issues. It fails to notify first responders who should act for you as a parent if you are unable to do it. And it forces you to return to your attorney when you want to change your mind. I've taken a great many phone calls from clients of other attorneys who needed to change the guardianship nomination, and when they called their attorney, they were going to charge them $600 to change their will. There's no reason for that. As a separate freestanding document, we can make it uber cheap for you to change your mind, and we want it outside of your will because we don't want to have to go through probate, send your will into probate, wait for it to be accepted as a last will and testament, and wait for a court to sign the order of the guardianship to the guardian. We want it immediately available the instant it's needed, okay? So I consider the way we used to do this as estate planners to be insufficient planning. And now that we know that there's a better way, we should do that. People often think that they don't need a separate plan just for their children. But that's actually the better way to go. When your financial plan is, say, one pillar of your estate plan, that's great. Then you can maneuver, you can manipulate, you can change your estate plan as needed. When your children's planning is separate from the financial plan, then you can maneuver, change it, adjust it, separate and apart from the financial aspects. That's just a better practice. The other reason why you need a separate plan is that you also need these short-term issues covered that traditional estate planning doesn't generally cover. So I do think that even if you do have one plan, you should have a separate plan for your children. Many people don't think that they need a plan because they leave their children with their parents, with their grandparents. That's wonderful, that's great. But like I said before, Merely depositing your children in the physical custody of a family member does not empower that family member to have legal control over your children. We actually want to transfer your legal custody of your children to that family member as well as the physical care. We want to kind of cut the state out entirely, just cut them out by empowering your family members to also take legal custody of your children. So we do that through those two legal documents, delegation of parental responsibilities on a temporary basis and an appointment of a long-term guardian. Those two documents basically shut the government out of your family's governance. And that's what we're looking for. We're looking for a nice tight nest of control and care around your children that doesn't allow the government to intervene in any material way. Now, they will send caseworkers out to check on the care of your children, but we want to basically say, hey, we've got this. Thank you very much. We appreciate your care, but you don't have to intervene because we already have the legal care and custody of our children all locked in. My favorite objection is, it's not going to happen to me. I don't need to plan because it's not going to happen to me. There does seem to be a certain amount of superstition when we talk about death and dying, and people seem to fall in one of two categories. One is, if I take care of my planning, it's not going to happen to me, so I'm going to plan because that will help prevent any kind of tragedy in my family. The other one is, if I give this any energy, then it's going to happen to me. So I'm not going to bring that upon myself by giving it any energy. I'm not going to plan. There's not much I can do if that is, or to convince you to do otherwise, if that is what's happening for you. I can say that I haven't had any measurable increase in death, dying, disability for my client base. There's no statistics to show that that's the case. And my personal belief is that when we address our death head on, when we actually embrace it as the reality of our future, we're all going to die, we're all terminal, that there's a certain liberation that occurs, a certain freedom that arises out of that certain knowledge that each day could possibly be our last. Absolutely could. Today could be mine. Tomorrow could be yours. And I don't know whose is whose. So we're in this together that way. And I would just like welcome you into the possibility that there is nothing you could really do to bring your own tragedy on, but that actually stepping into it can be empowering and liberating. So the next thing I want to talk about is how the system that we've designed helps the emergency response system identify that you have already taken care of your kids' legal business. We have a number of them. These are the 4 key pieces. One is a lock screen for your phone. Then we have wallet and glove box instructions for your wallet and car. We have window cling stickers for your home and auto. Then we also want to make sure that your babysitters know what to do, anybody who's taking care of your children. The first and coolest, every time I show this to a police officer, they think this is way cool. And I'll see if I can show you on my phone. Okay. I'm going to show you on my phone. Okay. So when I show this to first responders, hopefully you can see that. It says, in case of an emergency, oops, and it says who to call in case of an emergency. And it has my husband's name, my son, and 2 of my best friends on here as people to call in case of an emergency. So this is called a squawk screen. And if there is an emergency with you, first responders will absolutely look at your phone, see what they can find. If you give them the information right there, right in front of their face, you just make their lives easier. Now, we don't want to put your address on there. We don't want to put your kids' names, and we don't want to identify that you have kids, but that first person on the list is going to be a spouse if you have one, or one of your empowered legal caregivers for your children. And then your other 3 will be the other people. So we provide that squawk screen for you, and you can just put it on your phone as a lock screen. The next piece is that we want to give first responders something in your wallet. They're going to go through your wallet to see who you are. They'll take out all the contents to see what they can find, see if you have kids, see if they can identify an address of somebody to contact. Like your medical information, allergies, medical conditions that they need to know about should be in there. So we have a customized wallet card that goes in there, actually has a tab on it that says ICE on it. And it does contain your information, your allergies, your medical conditions, your children's caregivers. And in this case, we can actually put your address and some more specific information. We also have very cool window cling stickers that go on the inside of your car. They don't have adhesive on it. Go on the inside of your car. And it says, I have a chirp. Please see glove box for instructions. And then we place in your glove box, or actually you'll do it, but we'll provide it to you, a single fold instruction manual for who to call in an emergency. And it will tell people, the first responders, who your first, second, and third level responders are, so that they can, that's my son calling. Sorry about that. So it directs first responders to look in your glove box. It's awesome. And also we want a sticker on the front and back window of your home so that if first responders are coming to your home, that they can easily spot the bluebird with the call button on it to let them know that you have caregivers for your children and that they can rely on their authority to take legal custody of your children. We also want to make sure that your babysitters know who to call in an emergency and that they should not call 911 directly. They should call your children's legal caregiver first, get your child in the legal custody of your caregiver before they call 911 or the police station if you don't come home. So we need to educate our babysitters and our caregivers what their job and role is in making sure your children don't end up in protective custody or foster care. So we're actually creating our first training video for law enforcement and first responders. Sorry, it's my kid again. He's in college, so calls me when he needs stuff. So what I was saying is we're creating our first video for first responders and emergency personnel, police, sheriffs, associations, so that they understand what a children's emergency response plan is, what it can do, how it should be used, and what they can look for when they see that Bluebird logo, that they know that you have already taken care of your legal responsibilities for your children and that they can rely on the legality, thoroughness of the plan. So let me see what else we got here. Okay, there's 3 things that I want you to make sure that you understand that a children's emergency response plan can't do. Things that a children's emergency response plan can't do, slide, is it cannot alter the fundamental rights of another parent. I have gotten the question about, say a parent who is co-parenting with another parent, doesn't particularly like their co-parent, and they've asked, hey, if I die, can I give my parental rights to my family? No, you can't. I'm sorry. Cannot alter the fundamental rights of the other parent. If something happens to you, your child's legal custody will go to the other parent. If you don't like that, you need to talk to a lawyer and go to court, because only a court can alter the fundamental rights of parents, of both of you, which is a safety net so that parents who get sideways with each other aren't interfering with the other parent's rights. So unfortunately, no, this system can't be used for that. Also, I have gotten the question about, can this system be used to return the fundamental rights to another parent whose rights have been restricted or terminated? No, it cannot. You can't give your child back to their other parent if a court has already terminated or restricted the other parent's rights. So you can't do that. The third thing that a children's emergency response plan can't do, it cannot replace a proper estate plan provided by a qualified estate planning attorney. You need to get a lawyer to help you with that if you have resources to provide to your children. And this is where I'd like to encourage you to not cheap out on finding an attorney who can guide you through the process of creating a financial estate plan that provides for your children seamlessly and easily, and your children's guardian, the resources they need to raise your children. So a children's emergency response plan can't do that, but it can support and provide proper legal guardianship for your children. So those two together are what we're looking for. Right, your next steps. If you've listened to the last 40 minutes of me talking, you may be wondering, like, well, what do I do next? Great. Okay, so the next thing you want to do is go have this conversation with your partner. If you are co-parenting or married, the two of you should discuss this. If you are on speaking terms with your co-parent, I'm not going to suggest that if you are not on speaking terms with your co-parent and you're divorced, separated, never married, you do not need to have this conversation with your co-parent. But if you're married or you are closely co-parenting with your child's other parent, yes, have this conversation. Because you will want to decide on 3 or 4 local temporary parental delegates who can take legal custody of your children in an emergency. And then you can also decide on who would raise your children if you can't do it. We also want 3 or 4 alternates for that job. Make those decisions. They're tough decisions, but commit to doing it, even if it takes you several conversations. Be gentle with one another when you're conversing about this, but also be honest. If you're having to describe your feelings about your own families of origin or your partner's family of origin, be mindful that these are people that are, regardless of their current situation, they are family, and be kind and gentle with one another, and also be honest. The next thing to do is to gather the information for those 3 or 4 local people and 3 or 4 long-term guardians. Buy your children's emergency response plan and sit down and get it done. It can be done in about 30 minutes or less. And the system will lead you through your decision-making process. At the end of your decision-making process and your data entry, it will send your documents to our notary partner in Virginia automatically. You don't have to do anything to make that happen. You just click a button and it will send it off to that company. And the company that is called NotaryCam will reach out to you within about 15 minutes to set up a notary session to sign, witness, and notarize these documents. It's pretty cool. Now this company is open from 8 a.m. to 11 p.m. Eastern Time. So if you're on the West Coast, you'll have until 8 p.m. at night, or you'll have to wait until the next day. And it's really very easy. It's the quickest, easiest way we have been able to figure out how to do this to date. It's mind-bogglingly cool. So the next thing I want to just conclude by saying that this is your job. No one else can do this but you. And if you don't do it, then the system will do it for you. So I'd like to encourage you to gather up some courage. And if you have places in you that are afraid to do it, thank them. They're trying to keep you safe, and do it anyways, because only you can do it. If you don't do it, the system will do it for you. You may not like how it does the job for you. I'm going to sweeten the deal a little bit for you to suggest that you get it done right away. If you've spent the time to listen to this, 45 minutes now, then spend a little more time and get it done. To sweeten the deal and to get you on your way, if you purchase a children's emergency response plan at our website in the next 48 hours, and you use the promotional code PROMO1001, you will get $40 off our regularly priced children's emergency response plan. So the price really it just went up actually to $289. So the $40 off code will get you a children's emergency response plan at $249. So we encourage you to get it done so you can let it go. And if you have any questions, please feel free to email us at hello@gochirp.com. Remember that CHIRP is CHERP, not CHIRP, the Children's Emergency Response Plan. Our website is gochirp.com. gocherp.com, gocherp.com. And we look forward to getting your questions. I'm going to turn on the chat to see if we have any chats now. You are welcome if you have a question to ask that question. I'm not seeing anybody do that. You're also welcome to email me at hello@gocherp.com. I won't respond personally, but my staff will give me anything that looks like I should be responding to it. I will respond to legal technical questions personally, but the staff can't do that because they're not lawyers. So thank you so much for your time and your attention and your care for your children. And again, my name is Martha Hartney, and I am the CEO of the Children's Emergency Response Plan and the principal attorney at Hartney Law. Again, if you're a Colorado family, we welcome your contact to our law firm as well. And CHIRP is not a law firm. Hartney Law is a law firm. And so we can't give you legal advice at the CHIRP company, but we can over at Hartney Law. So if you want to give us a call about legal advice at Hartney Law, please feel free to set up either a quick call with me online at hartneylaw.com, call our office at 303-747-3909, or email info@hartneylaw.com, and I look forward to hearing from you. Thank you.